In reaction to the catastrophe of the Nazi regime and its atrocities, the Basic Law from 1949, Germany's post-war constitution, places great emphasis on fundamental rights and their effective protection. The text of the Bill of Rights focuses on liberty and equality rights, which are to be taken seriously. A powerful, distinct constitutional court is empowered to perform effective constitutional review. The guiding idea of the framers of the Constitution was a substantive criterion for limiting fundamental rights, which turned out to be proportionality. Proportionality and balancing have played a crucial role in Germany's legal system for more than 5 decades, plays a crucial role in a great many other national legal systems, in the legal system of the European Union, and in public international law. What is more, balancing nowadays is conceived as a fundamental operation in the application of the law on equal categorical par with subsumption, which alone was front and center in traditional continental jurisprudence. This is to say that proportionality analysis has increasingly been practiced by a great many courts in numerous jurisdictions over decades. With growing practical importance, proportionality has been, however, subject to theoretical analysis. A milestone was Robert Alexy's inquiry into proportionality and balancing against the backdrop of principles theory. In the first round, in his seminal monograph on fundamental rights from 1985 in German, and later in his publications on discretion and the weight formula from 2002, 2003, and henceforth. Balancing and proportionality have met, however, with different strands of criticism by some scholars. In this presentation, I shall focus on one particular strand of criticism. According to my German colleague Matthias Jestedt, Freiburg, balancing, proportionality, and the reconstruction of these phenomena against the backdrop of principles theory destroy the hierarchical structure of the legal system. This objection is not, however, completely new. It was already raised, for example, in the German debate on proportionality by Fritz Ossenbühl in the 1980s. Indeed, the respective jurisprudential foundations of, on one hand, the hierarchical structure of the legal system, Kelsen's pyramid, and, on the other hand, balancing and proportionality, entertain doubts whether they can be reconciled. The doctrine of the hierarchical structure of the legal system is part and parcel of the pure theory of law, reine Rechtslehre, as developed by Hans Kelsen and his colleagues and disciples in the Vienna School of Legal Theory, Wiener Rechtstheoretische Schule, the version of legal positivism in German legal culture in the 20th century par excellence. Principles theory, with its distinction between rules and principles, goes back to Ronald Dworkin's criticism towards H.L.A. Hart's positivistic theory. Dworkin used legal principles with a pronounced anti-positivistic impetus, and the argument from principles is brought forward as an argument against legal positivism by Robert Alexy. And this suggests that the doctrine of the hierarchical structure of the legal system forms an integral component of legal positivism, while balancing and proportionality seem characteristic for natural law theories. So, incompatible. That balancing cannot be reconciled with the hierarchical structure of the legal system seems to be confirmed by the fact that Hans Kelsen explicitly raised objections to the idea of balancing. In the first edition of this Pure Theory of Law, Kelsen fundamentally criticizes in paragraph 37 the so-called methods of interpretation in the section on interpretation. He criticizes the idea that the traditional canons of interpretation could lead to one right answer, einzig richtiges Resultat. In the following, one reads, now quote, Kelsen, even the principle of the so-called balancing of interests is merely a formulation of the problem here and not a solution. It does not supply the objective standard according to which competing interests can be compared with one another as a means of settling conflicts of interest. Close quote. And in the second edition of the Pure Theory of Law, around 3 decades later, one finds the very same passage. Finally, balancing is the method of establishing conditional priority between and among competing principles. By contrast, the hierarchy of derogation, in which the Roman maxim lex superior derogat legi inferiori applies, this establishes unconditional or absolute priority between and among norms at different levels. Since unconditional or absolute priority rules out conditional priority, only norms at the same level of the hierarchy of derogation can be balanced. This is to say that balancing across different levels of the hierarchical structure of the legal system seems hardly possible. The principle at a higher level would take always unconditional priority over any principle at a lower level. There is agreement that the doctrine of the hierarchical structure of the legal system forms an integral component of the reconstruction of modern legal systems. This makes the argument of the destruction of the hierarchical structure of the legal system, on first sight, powerful. Should it prove impossible to find a reconstruction in which both the doctrine of the hierarchical structure on one hand and proportionality and balancing on the other can be reconciled, one element had to yield. There are, however, no alternatives or functional equivalents for these two elements in sight. The situation is somewhat complicated by the fact that we have not yet arrived at an uncontested reconstruction of balancing and the hierarchy of the legal system. This applies most notably to the idea of formal principles, which are crucial for assigning legal power to different organs in the process of concretizing the law at different levels. It's ongoing discussion. Against this backdrop, my effort should be understood as a first attempt to carve out the decisive questions and develop approaches to answer them. It's not the final answer. In what follows, the doctrine of the hierarchical structure of the legal system shall be sketched, and then, second, the idea of balancing according to principles theory will be briefly in the limelight. Finally, outline will be given how these phenomena, I think, can be reconciled. So first, the doctrine of the hierarchical structure of the legal system. This doctrine was developed by Kelsen's younger colleague Adolf Julius Merkel, rather than by Kelsen himself. In the development of Merkel's conception of the hierarchy, two periods can be distinguished. To begin with, Merkel developed key aspects in various articles from 1916 to 1922, more than 100 years ago. This early period culminates in a coherent and comprehensive exposition in a section of about 20 pages in his treatise Die Lehre von der Rechtskraft, published in 1923. A particular focus in Merkel's writings of this early period is the question which levels are necessarily part of every legal system. According to Merkel, there are only two necessary levels in every legal system, namely the original norm. This norm is, by and large, Kelsen's famous basic norm, in German Grundnorm. And second necessary level, the level of the coercive acts. This interesting jurisprudential thesis raises quite a few questions. I disagree with Merkel. However, I shall focus today on the hierarchical structure that is characteristic of modern legal systems, because we are talking about modern legal systems. Kelsen began to adopt key elements of Merkel's doctrine in 1923, this very year. Merkel's final publication on the issue of the hierarchical structure of the legal system is his famous Prolegomena, eine Theorie des rechtlichen Stufenbaus, is the title in German. Prolegomena, eine Theorie des rechtlichen Stufenbaus. In short, Prolegomena. In this essay, Merkel focuses on the issue of hierarchy in modern liberal democracies, Rechtsstaat, dem parlamentarische Einrichtungen eigentümlich sind, the original phrase. Henceforth, this version of Merkel's doctrine of the hierarchical structure formed an integral component of the Pure Theory of Law, first edition, which is shown by the respective chapters in Kelsen's main works on the classic Pure Theory of Law. Modern legal systems vary to a certain extent with an eye to the number and the kind of the levels in their hierarchy. As a rule, they boast of a constitution, and this is actually my modest handout, which I sent. A constitution, Grundnorm, basic norm at the very top, then constitution, then levels of general norms below the constitutions, parliamentary statutes and regulations would be two typical levels, and then individual norms. And there is the basic norm, as I mentioned, at the very top. There is the coercive act at the very bottom, which is a fact. And there is something that I call fully concretized and individualized norms, which is not contained in the original Pure Theory of Law, but this is actually something I think we have to add. But this is not my main topic today. Beginning at the top, the basic norm. While H.L.A. Hart considered the existence of a constitution of a legal system to be a mere social fact, Kelsen and his colleagues and disciples in the Vienna School of Legal Theory conceived of the constitution as a set of legal norms in the strict sense, created in the exercise of the basic norm as a characteristic component of the Pure Theory of Law. Already Adolf Julius Merkel's early reconstruction of the hierarchical structure contained an original norm exhibiting the characteristics of Kelsen's basic norm of a dynamic system of norms. First, it enthrones and legitimizes legal power to create valid legal norms. It is a norm that is thought rather than a norm of positive law. And finally, it creates the unity of a legal system. These are the key characteristics. The Constitution. The first level of positive law in the hierarchical structure of the legal system is the Constitution in a material sense. The essential function of the Constitution consists in governing the organs and the process of the creation of general law, that is, of legislation. In addition, the Constitution may determine the content of future statutes, for example, constitutional rights. This is to say that two kinds of requirements are set. First, procedural requirements, organs and the process, and second, requirements with an eye to the content of provisions in statutes. Content. next level. Below the constitutional level, the level of statutes that are created in parliamentary legislation is characteristic of modern liberal democracies. Often, there is another level of general norms below the level of parliamentary statutes, a level of general norms that can be amended under less onerous conditions, thus allowing for greater flexibility than parliamentary statutes, namely statutory instruments, ordinations, regulations. What is more, customary law can be part of a level of general norms if and when the Constitution provides for the creation of customary law at that level. This legal power can be established explicitly by means of a provision of the Constitution, or it can be provided implicitly by customary constitutional law. General norms below the Constitution provide for the organs in the process of creating individual norms by the administration and by the judiciary, and for the content of these individual norms. While the Constitution often only sets an outer frame for general norms usually leave less discretion for the administration and the judiciary, but they may leave some discretion. If and when the administration and/or the judiciary decide cases based on general norms, the supporters of the pure theory of law conceive this to be the creation of individual norms. Against the backdrop of the widespread ideas that norms are, in short, something like general commands, this may strike one as surprising. It is, however, only consequent if you conceive of legal ought in every imaginable form, also in the form of a norm that has been concretized in a given individual case as norm, because it says you ought to do something. What is more, contracts count as a special kind of individual norm, an individual norm that was created by two parties in exercising legal power, granted by general norms, and rooted ultimately in the Constitution. The writings of the Vienna School of Legal Theory on the pure theory of law are not clear as to whether the paradigmatic individual norms to which these scholars repeatedly refer require further concretization before the coercive act can be carried out. At any rate, the fully concretized norm represents the bottom level in the hierarchical structure of the legal system. The application of the individual norm in the sense of the fully concretized norm then leads to the coercive act. The coercive act, however, unlike all phenomena above in the hierarchy of the legal system, is a fact rather than a norm. And then this is basically an explanation of the handout. In an analysis of the hierarchical structure of the legal system, it is crucial to distinguish between two different relations, namely the relation represented by the hierarchy of conditions and the relation of derogation. The relation represented by the hierarchy of conditions is a necessary relation between the levels in the hierarchy. This relation turns on legal power, for the norm imposing a condition confers legal power to create other norms, those norms subject to this condition. According to the relation of represented by the hierarchy of conditions, norm N1 imposes conditions on N2. The inverse relation is being subject to conditions. Norm N2 is subject to conditions stemming from norm N1. This relation is transitive, and the same applies to the inverse relation. The norms that impose conditions on other norms are understood as higher norms, the norms subject thereto as lower. The basic norm at the apex of the hierarchy, the top of the pyramid, exhibits a complete absence of conditions on the ground that it is not subject to any further conditions. This is the point of the basic norm, actually. The level of individual norms created by the judiciary or the administration is found, at least on first glance, in Kelsen's system at the bottom of the hierarchy of norms. All levels of the hierarchy found between the basic norm and the level of individual norms both impose conditions on lower levels of norms and are subject to conditions stemming from higher levels of norms. Owing to the nature of these norms as both imposing conditions on other norms and being subject to conditions stemming from other norms, Merkel characterizes them as Janus-faced. According to the relation of derogation, norm N1 derogates from another norm N2 if and when the former norm takes unconditional or absolute precedence over the latter norm qua form. It is often assumed that every norm that is higher in terms of the relation represented by the hierarchy of conditions is also higher in terms of derogation. This seems understood, for example, for the relation between the Constitution and parliamentary statutes. If there is a conflict between a norm of the Constitution and a norm in a parliamentary statute, the unconstitutional parliamentary statute has to yield. Kelsen and Merkel considered the parallel between the two hierarchies to be an issue decided by positive law rather than analytical necessity. And there is, indeed, something to be said in support of this thesis. The reason for the typical parallel between the two hierarchies is that legal power at the higher level is protected by means of derogation from being repealed or amended by the norms that were created in the exercise of this very same power. For example, if the Constitution derogates from parliamentary statutes, the parliamentary statute has no power to change the constitutional limits for parliamentary statutes with an eye to process or substantive content. This is to say that for the typical levels of national law in modern liberal democracies, the parallel between the hierarchy of conditions and the hierarchy of derogation suggests itself. It ought to be emphasized, however, that this parallel is not a strict necessity. It is supported by the reason mentioned above, the protection of legal power from being repealed or amended by the norms created in the exercise of itself. As far as this reason extends, the parallel structure would be the rule rather than the exception. Where the weight of this reason diminishes, or where this reason carries no weight at all, things may well be different. The pure theory of law emphasizes also the relativity of the contrast between creating and applying the law. According to this theory, most legal acts represent both the application and the creation of law. Establishing the Constitution counts both as the application of the basic norm and as the creation of the Constitution. Legislation counts as both the application of the Constitution and as the creation of statutes. Adjudication counts both as the application of statutes and as the creation of individual norms. There are only two phenomena in the hierarchy that do not exhibit this dual nature. The presupposition of the basic norm counts as law creation alone, and the coercive act represents law application alone. Both Merkel and Kelsen place great emphasis on the thesis that adjudication and administration are not law application alone, as traditional legal methodology at the time would have us believe. They count too as law creation. Kelsen's approach to interpretation is closely connected to the hierarchical structure of the legal system. The further one moves downwards in the hierarchy, the greater the concretization of the law, for lower levels are bound by the decisions on content taken at higher levels. Although the basic norm has no substantive content, the Constitution sets an outer frame for the content of law at lower levels. Further concretization is brought about by legislation, which will ordinarily leave considerable discretion. Finally, individual norms represent still greater concretizations. Kelsen emphasized the discretion of the person or organ of state that is empowered to concretize, while one moves downwards in the hierarchy. There can be more or less discretion, but there is, according to him, at least some discretion. There is no one right answer in concretizing a higher norm. Inside the frame that the higher norm sets, the act of will of the person or organ of state empowered to concretize the lower norm proves decisive. Thus, the interpretation by the empowered person or organ of state counts as authentic interpretation, while other persons can only suggest concretizations, their suggestions are merely non-authentic interpretation. Good. Now, principles. Ronald Dworkin laid the foundations of modern principles theory. Robert Alexy picked up these threads and insights from classic German literature on the issue of principles and developed some elements further into a comprehensive and coherent distinction of rules and principles in modern principles theory. Principles theory has been the subject of a protracted debate. In what follows, only the aspects that are crucial in the context of the reconstruction of balancing in the hierarchical structure of the legal system can and shall be in the limelight. According to the strong separation thesis, there is a logical difference between rules and principles. A norm can either be a rule or a principle. It cannot be both or neither nor. Characteristic of principles is that they exhibit the dimension of weight, which rules lack. Principles have an entity to be optimized, which ought to be realized approximately to the factual and legal limits. The characteristic form of application of principles is balancing. The principle that yields to the other in the balancing does not lose its legal validity. So it's not a conflict, it's a competition. By contrast, rules contain fixed content under which one can subsume. In the case of a conflict between two rules, one of the rules cannot merely yield to the other without being rendered invalid. One of the rules must be declared invalid. There are maxims for such conflicts such as lex superior derogat legi inferiori or lex posterior derogat legi priori. Rules by themselves cannot be balanced since they do not exhibit the dimension of weight. They can, however, refer to principles so that their content depends on balancing other norms, principles at the end of the day. A distinction that has been in the limelight in the debate of principles recently is the distinction between substantive and formal principles. I mentioned this already. Substantive principles have an entity to be optimized which is fixed from the outset in terms of substantive content. For example, the entity to be optimized of the principle of environmental protection in the German Basic Law requires prima facie that the German state that no actions be performed that harm the environment, and that such actions of individuals or companies be discouraged and prohibited. Environmental protection. Formal principles. It is characteristic of formal principles that a person or organ of state is empowered to determine in a given frame the substantive content of the entity to be optimized of the formal principle. Before this determination has taken place, the entity to be optimized of the formal principle has not been concretized. Thus, a balancing against competing substantive principles cannot be undertaken at this stage. Only once the determination of the entity to be optimized with an eye to the substantive content has taken place, the structure of competing formal substantive principles is the same, so that a balancing according to the general rules of balancing principles can take place. One can distinguish further between dependent and independent formal principles. From the structural point of view, dependent principles are a particular instance of formal principles. It is, however, this special form of formal principles that has been front and center in the debate on the reconstruction of discretion for the democratically legitimated parliament vis-à-vis a constitutional court, even though their nature as dependent formal principle has usually to date not been recognized. The entity to be optimized of a dependent formal principle is that a balancing decision taken by a person or organ of state on the balancing of competing substantive principles ought to be respected prima facie. Okay, coming back to general principles theory, right at the beginning of the development of modern principles theory, Robert Alexy presented the law of competing principles. If and when two principles, P1 and P2, compete, so that a decision of which principle has to yield is required, the balancing actually creates a rule. Now, I quote this law. Quote, if principle P1 takes precedence over the principle P2 in circumstances C, and if P1 gives rise to legal consequences Q in circumstances C, then a valid rule applies which has C as its prothesis and Q as its apodosis. C leads to Q. To be sure, the rule that is created thereby boasts of definitive legal validity only in the respective legal system if all relevant principles in this legal system are considered in this balancing, and second, if all relevant factual circumstances are factored in. Only under these circumstances, all principles, all facts. The rule created in the balancing, according to the law of competing principles, is fully concretized, otherwise it is only partially concretized. In the debate on principles theory in the last 10 to 15 years, the laws of balancing played a crucial role. The first, or substantive law of balancing, which reads, quote, the greater the degree of non-satisfaction of or detriment to one principle, the greater must be the importance of satisfying the other was part of Alexy's first exposition of principles theory, 1985. Nearly 2 decades later, he added, with an eye to epistemic issues, cognition problems, epistemic issues, the epistemic law of balancing, the more heavily in interference with the constitutional right weighs, the greater must be the certainty of its underlying premises. What is more, Alexy developed the weight formula, which explains the variables and quantities in the balancing with utmost clarity and precision. The debate on this important and complex issue is, however, an issue in and of itself which cannot be pursued further here. If you have questions, we may take this up in the discussion. At the beginning of this essay, some skeptical questions with an eye to balancing in the hierarchical structure of the legal system were mentioned. These questions shall now be addressed against the backdrop of the outlines of the theory of the hierarchical structure and the theory of balancing. Good. First, including balancing into the hierarchical structure does not fail owing to the argument of the hierarchical structure of the legal system on one hand and balancing principles on the other, allegedly presuppose incompatible legal philosophies. This is not the case. There can be no doubt that the theory of the hierarchical structure of the legal system was developed in the context of a paradigmatic positivistic theory of law, the pure theory of law. At the heart of this theory, one finds legal power, or, in other words, the legal competence, which is distributed between and among different persons and organs at different levels in the process of the creation of the law. As a positivistic theory, the pure theory of law denies any necessary connection between law and morality. This is to say that the legal power to create law is not limited by a necessary connection between law and morality on any level in the hierarchical structure. This is not to say, however, that the converse argument, according to which a non-positivistic theory of law considers the whole content of the law to be determined by morality or natural law, holds true. To date, no theory of morality has been suggested that would convincingly determine a whole legal system down to every detail. This corresponds to the fact that non-positivistic theories of law can only be realistically be supported by reference to the weak connection thesis, according to which only extreme injustice deprives positive law of its legal character or legal validity. Below the threshold of extreme injustice, non-positivistic theories face the same problem as positivistic theories in general. In the absence of substantive criteria, formal criteria become key. This is to say that a non-positivistic theory will need to refer to persons or organs of state that are empowered to create law at different levels. In other words, will need to refer to some form of the hierarchical structure of the legal system. Natural law needs also the hierarchical structure. This is the point. Second, Dworkin introduced the idea of legal principles in his criticism of legal positivism and hinted at an intrinsically non-positivistic dimension of principles. This is far less clear for policies, even though, according to Dworkin, both kinds of norms are principles in the generic sense, which have the same structure and thereby both stand vis-à-vis rules. Alexy characterizes principles by their structure, namely the fact that they can be balanced and require balancing. The argument from principles in the context of his non-positivistic theory actually is based on the argument from correctness rather than on structural properties of principles. The crucial foundation for the argument from principle, Alexy's argument from principles, as a non-positivistic argument is Alexy's correctness thesis, which is the result of applying the argument from correctness within the framework of the argument from principles. According to the argument from correctness, quote, individual legal norms and individual legal decisions as well as legal systems as a whole necessarily lay claim to correctness, close quote. If one takes the correctness thesis and the other elements of the argument from principles for granted, the question as to whether positivistic principles can be imagined is rendered senseless, because all legal norms and consequently all legal principles have an inherent moral dimension. If one, however, rejects the argument from correctness and the correctness thesis, the question whether a positivistic theory can provide for norms with the structure of principles makes, by all means, sense. Of course, this meant that a balancing judgment would not raise the claim to moral correctness, as the correctness thesis in the context of the argument from principles would have us believe. Be that as it may, it does not rule out that a positivistic theory provides for norms with an entity to be optimized that ought to be prima facie realized to the greatest extent possible, with an eye to factual and legal limits. In other words, provides for principles. And on closer inspection, also Kelsen's explicit rejection of balancing needs to be put in perspective. The quotation mentioned above is from his Kelsen's Pure Theory of Law, according to which balancing needs to be rejected since this method would not provide any yardstick for the concretization of norm. Is found not without reason in the section of interpretation rather than in the section on the hierarchical structure of a legal system. Kelsen's main impetus goes against the idea that one could justify a single right answer by means of intellectual operations in the application of the traditional canons of interpretation. He argues that the result of applying the canons of interpretation could only be the discovery of the frame that the norm to be interpreted represents. In the same breath, he rejects the idea of balancing, since this method could not justify a single right answer either. This is to say that he rejects balancing for the same reason as interpretation according to the orthodox understanding of a single right answer. If this is true, and I think it is, Kelsen would not object to balancing if balancing leads to a frame rather than a single right answer, just as he does not object to interpretation insofar as this method leads to a frame rather than a single right answer. In fact, in early modern principles theory, Ronald Dworkin supported the idea of a single right answer even in hard cases. It is crucial, however, to understand that this thesis is not necessarily an integral component of principles theory. And in the recent debate on the structure of balancing, discretion has received and continues to receive a great deal of attention. Different forms of structural and epistemic discretion give rise to a significant extent of discretion in the balancing. This is to say that principles theory has long progressed beyond Dworkin's single right answer thesis and has accepted that balancing typically leads to a frame rather than just one answer. It was already mentioned that in the hierarchical structure of the, according to the pure theory of law, interpretation and the concretization of the law are closely interconnected. The legal power to authoritatively apply the law which is at the same time to some extent the creation of the law, is distributed over different levels in the hierarchy. With every step downwards, the law becomes more and more concretized until one arrives at the fully concretized norm. In Adolf Julius Merkel's words, the final phenomenon of the law. End- und Totalerscheinung des Rechts. Strikingly, balancing also leads to a concretization of the law and has a creative dimension too. According to the law of balancing, taking a balancing decision means creating a rule. If all relevant principles and all relevant facts are taken into consideration, the result is a fully concretized norm. This parallel becomes even more obvious by the fact that principles exhibit argumentative force on one hand, but leave some extent of discretion on the other, with an eye to a review of a balancing decision by other organs or organs of state, for example, a constitutional court. Now, how can the balancing, just as interpretation in Kelsen's sense, be distributed over different levels in the hierarchy? It is often insinuated that a judge or administrator concretizes in one single step constitutional principles all the way down to a fully concretized norm. To quote again Matthias Jestedt, principles theory fails, he says, to explain, quote, which content of the law is provided for at which of the different level in the hierarchy of the legal system. Close quote. A closer look reveals that this is not true. The highest level of the hierarchy in which balancing legal principles play a role in concretizing the law is the level of parliamentary legislation. In the process of enacting parliamentary statutes, the parliament balances constitutional rights and other constitutional principles. To be sure, the legislator is not committed to simply reproduce a statute that is fully predetermined by the Constitution. There are, most notably, three reasons for this. To begin with, the Parliament has often end-setting discretion. This is to say that Parliament is empowered to pursue legitimate ends that are not explicitly or implicitly banned by the Constitution. Such ends become principles with constitutional status only by means of the authoritative decision by Parliament. Second, there may well be structural discretion for Parliament. Structural discretion exists where there are two options available and the Constitution is indifferent which of the two options is chosen. In particular, this is the case in a stalemate in the balancing, which is characterized by the fact that none of the competing principle outweighs the others. Third, the cognition of empirical normative premises can be uncertain, which leads to epistemic discretion. This is to say, as I already mentioned, that the Constitution sets a frame for legislation rather than fully determines a particular statute. The legislator can take, inside the frame set by the Constitution, two different kinds of decisions. First, he can take strict decisions. Such a strict decision is characterized by the fact that a certain conditioning fact always leads to a certain legal consequence. According to Section 53 of the German Aliens Act, a foreigner must be expelled from Germany if he or she willfully committed a crime or offense and received a jail sentence of at least 3 years. In applying this parliamentary statute, subsumption rather than balancing is key. If the foreigner receives such a sentence, law below the Constitution definitely requires that he or she be expelled. Second, Parliament can take relative decisions, which are to be considered in a balancing decision at lower levels. For example, according to Section 55, Paragraph 2, Number 2, German Aliens Act, a foreigner can be expelled if he or she has breached the law more than sporadically or more than in a merely negligible fashion. This is, however, subject to a balancing decision taken by the administration, in which, among other aspects, personal and economic ties of the foreigner in Germany and implications for his or her family life have to be taken into consideration. Other examples from German administrative law could be given, and I suppose that this is true for a great many other legal systems. Such relative decisions by the legislator, decisions that narrow the frame for the level below, but leave some discretion to be filled by balancing, demonstrate that balancing can indeed be distributed over different levels of the hierarchy. The result in a chain of concretization by means of balancing over the hierarchical structure. Characteristic of interpretation in the doctrine of hierarchical structure, according to the pure theory of law, is authentic interpretation by the person or organ of state empowered to take the decision, which is contrasted with non-authentic interpretation. Now that there is widespread agreement that balancing gives rise to discretion inside a frame, the method of balancing resembles traditional interpretation in the hierarchical structure from a structural point of view. What is more, the category of legal power, Ermächtigung, is not only front and center in the hierarchical structure according to the pure theory of law, it plays an increasing role in the reconstruction of balancing according to principles theory. And this suggests to transfer Kelsen's distinction between authentic and non-authentic interpretation to balancing. Authoritative balancing is performed by the person or organ of state empowered to take the balancing decision. Suggestions by anyone else on the outcome of balancing counts as non-authentic balancing. In fact, the parallels between interpretation in the hierarchy of conditions and balancing in the hierarchy of derogation are so striking that one wonders whether Kelsen would have actually approved of the idea of balancing had he known principles theory. It's a speculation, but I think it is a reasonable speculation. Finally, the question remains of whether and how balancing across the levels of the hierarchical structure can be reconciled with the lex superior maxim, which expresses the hierarchy of derogation. Again, the category of legal power is key. Organs at lower levels can be empowered to introduce entities to be balanced in the sense of principles theory. This power is implied by end-setting discretion, which has already been mentioned. A well-known example stems from the reconstruction of the limitation of fundamental rights. Many constitutional rights in the German Basic Law have limiting clauses with no exhaustive list of limiting reasons. This is to say that the legislator is empowered to limit these rights by reference to legitimate ends, that is, ends that are not by themselves prohibited by the Constitution, such as, now those which are prohibited, racial segregation or religious homogeneity. These legitimate ends that are not forbidden are expressions of an entity to be optimized in the sense of principles theory, and this principle becomes valid or acquires its content because of the decision of Parliament. If this principle would, because of receiving its validity or content by means of a decision of the Parliament, considered to be a norm below the level of the Constitution, it would be difficult to see how this could be balanced against principles at the constitutional level. To be sure, even such principles have constitutional rank. Alexy introduced, in his seminal monograph on principles, theory, and constitutional rights, the distinction between constitutional status of the first degree, principles that are explicitly provided for in the Constitution, and constitutional status of the second degree, principles that are established by the legislator. And they both have constitutional rank. That is the point. Constitutional status of the second degree can be explained by means of legal power, which is granted to certain organs to introduce principles that are balanced against principles with constitutional status of the first degree without formally amending the Constitution. From the structural point of view, legal power to introduce principles with constitutional status of the second degree could even be delegated to organs at levels further below, such as the administration that enacts statutory instruments. For substantive reasons in German constitutional law, the principle of democracy and the rule of law require, however, that important decisions be taken by the directly democratically legitimated parliament, and the creation of a principle with constitutional status of the second degree counts as an important decision in the sense of the so-called Wesentlichkeitstheorie. It's our constitutional law. This is, however, a matter of positive law rather than a matter of legal theory, the German situation. It was already mentioned that the balancing of a given set of constitutional principles with constitutional rank of the first and or second degree becomes more and more concrete the more one moves downwards in the hierarchy, because the factual premises considered in the balancing become more and more concrete. As long as a balancing judgment taken at a lower level respects all decisions taken in more abstract balancing judgments at higher levels, there is no conflict of norms and thus no issue with derogation. To sum up, balancing can well be reconciled with the hierarchy of conditions, and there is no issue with balancing in the hierarchy of derogation. On closer inspection, the argument from the destruction of the hierarchical structure of the legal system does not present a serious challenge for the reconstruction of modern legal systems against the backdrop of principles theory. Thank you very much for your kind patience. Thank you.